Where's in the judgment? I'll try and come round and get
it. Are we all ready? Splendid.
Got eyes?
Yes, Mr. Beaufort.
Lord, before the short adjournment, I was attempting to give the court an overview of the company's answer to the appeal.
Yes.
And one can, I think, readily divide the appeal really into two parts. The first part is, was the no worse off test properly satisfied? And the second part is, did the judge properly exercise his discretion to sanction the plan? And can I just give you a brief overview of our answers to those 2 points before, as I said, addressing the grounds in order? We submit that the judge made the following key findings in satisfying himself that the no worse off test was satisfied. The first finding was that the relevant alternative to the plan was a liquidation of the group, and that was common ground. The second finding was that in that relevant alternative, all of the plan creditors would be likely to recover 63% of the principal amounts owing to them. The third finding was that on the balance of probabilities, if the plan becomes effective, all of the plan creditors, including the 2029 plan creditors, are likely to be paid in full. And it's necessary to deal with that third point in some detail by reference to the relevant passages of the judgment, given my learned friend's submissions of yesterday. Now, by way of background to this, the judge's determination of the likely returns to the note holders turned on two variables. First, the value of the group's real estate portfolio as at Q2 or Q3 2022, and second, the likely future prices of the group's real estate until 2026-2027, when the asset disposal programme is expected to be complete. So those are the two variables. Starting point, what were the properties worth when they were most recently valued, and what are the movements of the prices likely to be over the disposal programme? Now, as to the first variable, the judge accepted the company's evidence as to the value of the properties as at Q2 or Q3 2022, and one sees that from paragraphs 167 and 175 of the judgment. Now, can I just briefly show your lordships those paragraphs? So we're in the second volume of the core bundle, tab 5.
So, third in our case.
Third in your case, I apologise. And one needs to go to page 830 first for paragraph 167.
Yep.
And there, the judge says that doing the best he could, that he was satisfied that it was more likely that CBRE have valued the yielding assets more accurately than Knight Frank, and he finds on a balance of probabilities that the value of the ADO portfolio and the A&W portfolio, the acronyms don't matter, was 5.384 odd billion as at the 30th of June 2022, and 5.277 billion as at September 2022. To be clear, therefore, he rejected the Knight Frank evidence and accepted CBRE's evidence. So that's paragraph 167 relating to the yielding assets.
He seems to have treated it as if you just had to choose between the two.
He did.
Which is a bit odd for valuation. I mean, it's very common to have two values and for the court to alight on a figure somewhere between the two.
Well, I don't know whether my lord has had a chance to at least dip into the judgment in terms of how Mr. Gerlinger for Knight Frank approached his expert evidence.
I read the judgment.
Yes. What he didn't do was actually give any valuations to any of the particular units. He took them in clusters and applied some sensitivity differences to valuations that had been reached, and therefore arrived at a different valuation for each cluster of properties. And effectively, for that and a number of reasons, that the judge rejected his valuation evidence and relied upon CBREs, who had put in or had produced to the company extremely lengthy valuation reports for each and every one of the yielding properties on which the judge felt able to rely.
Yet another consequence of timing.
Sorry?
I mean, that was a consequence of timing, wasn't it, amongst other things? I mean,
It wasn't that Mr. Gerlinger was incapable of doing a valuation. It was that he was under a great deal of pressure.
Whether he would have done the same exercise as CBRE had done given more time, I don't know. It would obviously have been an extremely expensive exercise to undertake. Timing was said to be a reason why he did less than that.
I mean, I don't want to go back over the ground we covered just before lunch, but when people know that there are going to be valuation disputes, which is, I'm afraid, a hallmark of Part 26A now, it would seem, the question of the differential in access to information and time available to produce valuations between the planning company on the one hand and an opponent on the other is going to become more acute.
Yes, I accept that.
And the judge did say at 164 the reason for Mr. Gerlinger's approach was that he hadn't, in the time available, been able to value asset by asset. I mean, it's not a criticism as such, it's just a consequence of the way that things happen by the look.
Yeah, my lord, and I accept that, but what is not capable of being disputed is that the judge was satisfied with the CBRE valuation evidence, preferred it to Mr. Gerlinger.
But I don't. I didn't understand from Mr. Smith that was a live issue on the appeal.
It's not. The live issue on the appeal is whether the judge was in fact satisfied on the no worse off test based on our evidence, or whether he took into account and wrongly relied upon, as Mr. Smith says, the alternative case. Yeah, that's the issue, and what I'm doing is just showing you the relevant findings that get you to our punchline, which is that on the balance of probabilities, he decided that everyone would be likely to be paid in full based on the evidence that he accepted.
Yes.
So one does have to start with the valuation evidence.
Okay.
Lord, paragraph 175 is the next paragraph to go to. It's again doing the best he can. It's more likely that NAI Apollo have valued the development assets more accurately than Knight Frank, and he finds on a balance of probabilities that the value of the development assets was 2.298 billion as at the 30th of June 2022. So that's his finding of fact in relation to that. He then turns to the second variable, and for that can I show your lordships please paragraph 216 of the judgment, which is on page 860. And there he rejects the approach of deciding which of the BCG report and the Knight Frank report is the more reliable, and says, in my judgment, Mr. Justice Zaccaroli was not attempting to formulate a new test in Re Hurricane, merely to explain how he would have approached the evidence in general terms if he had not rejected the plan company's evidence on the relevant alternative. In Virgin Active, Mr. Justice Snowden described the dispute between the parties as primarily a dispute as to valuation, and stated that as a matter of principle, the normal civil standard of proof applies to a valuation dispute. And then the critical words after, in my judgment, the present case involves a similar valuation dispute. I follow Virgin Active and also apply the balance of probabilities. This means that it would have been open to the court to reject the evidence of both Mr. Wolfe and Mr. Gerlinger as unreliable, and to decide that the plan company had not established on a balance of probabilities that no worse off test was satisfied. But he doesn't do that, and can my lords please read to yourself paragraph 217, which I think Lord Justice Nugee had identified yesterday. And one doesn't need to read the reasons for the time being. It's just the critical words are, I find on a balance of probabilities that if the plan is implemented, the group is more likely to realise the sums forecast in the BCG report than the sums forecast in the Knight Frank report. and that it is likely that the 2029 plan creditors will be repaid in full. Now, there are two connected findings of fact here. First, that the BCG report is more likely to be correct than the Knight Frank report. And the second and critical finding that is that it's likely that the 2029 plan creditors will be repaid in full. And that's a conclusion that the judge expressly reached on the balance of probabilities. And then that is bolstered in paragraph 290, which was the paragraph I invited your lordships to look at yesterday, where the judge says, I prefer the evidence of Mr. Wolfe to the evidence of Mr. Gerlinger in relation to the proceeds of the future sales of the group's assets, and I find, on a balance of probabilities, that if the plan is implemented, the group is more likely to realise the sums forecast in the BCG report than the sums forecast in the Knight Frank report, and therefore, underline therefore, that the 2029 plan creditors will be repaid in full. On this basis, the no worse off test is satisfied. He then says, I'm also satisfied that the test is satisfied on the basis that the future valuations in the Knight Frank report are accurate and that Mr. Gerlinger's insolvency discount of 5% is also accurate. Now, we'll come on to, in ground 7, to look at the alternative case as it became known. But critically, one has in paragraph 290 a very clear finding on the balance of probabilities that the plan creditors will be repaid in full. So, and that on that basis, the no worse off test is satisfied.
You emphasise the word therefore, but
Yes.
It doesn't seem to me that the second finding follows necessarily from the first. Just because A is more likely than B, doesn't mean that A is likely. I mean, you can quite properly say I prefer the analysis of the plan company's experts to those of the opponents.
Yes.
But simply saying that I think this is better than that is not the same as saying, and therefore I find that you will be repaid in full. I mean, that's a step beyond, which is I'm satisfied that it's more likely than not that you will be repaid in full.
Well, what he says is, on the balance of probabilities, the plan will lead to the sums forecast in the BCG report being realised. If they are realised, then there would then be enough money to enable all of the 29 plan creditors to be paid in full.
Yes. Well, I mean, as you say, he's twice expressed himself as finding on the balance of probabilities that there will be a full repayment.
Yes.
But those are findings as to what's likely. You can't, as I said to Mr. Smith yesterday, you can prove that something did or didn't happen. You can't prove what will happen. All you can do is assess the likelihood of something.
Well, that is obviously correct. There are 2 points that the court has to address. The first one is a jurisdictional condition. Is the no worse off test satisfied? And that's what he's focusing on here.
Yes.
One doesn't, and we don't submit, that just because on the balance of probabilities the no worse off test is satisfied in the way that it's satisfied, likelihood of payment in full, that when one comes to the exercise of the discretion, one assumes that everyone will be paid in full and that there will be no risk.
Yeah.
That's plainly something that has to be weighed in the balance when deciding whether or not to sanction the scheme. So one has to differentiate, in my respectful submission, between the jurisdictional condition and the exercise of discretion. Yes. And it doesn't follow, and it's never been our case, that simply satisfying the no worse off test on the balance of probabilities, either simpliciter or with a finding on a balance of probabilities of payment in full, that answers the discretion test.
Yes.
Or that the uncertainty does not have to be considered.
Just because you found it's more likely that the creditors will all be repaid does not mean you then assume when looking at discretion that they will necessarily all be repaid, because as he himself says, there's a spectrum and everything is uncertain, and there are risks involved.
Yes, that's quite right. And my lord, the point I was going to make next is, for the purposes of the exercise of the judge's discretion, he was perfectly entitled to take into account that notwithstanding the satisfaction of condition A, on the balance of probabilities, the outcome is uncertain. The point that my lord has just made. So that brings us on then to discretion. And one accepts that in paragraphs 290...
Just before you move to discretion,
yes.
That way of putting it suggests that you don't need your alternative case for condition A to be satisfied. You
Correct.
say condition A is satisfied simply on those findings as to your primary case.
That's right. It was he decided on a secondary basis the test was also satisfied with reference to the secondary case. But if on the balance of probabilities he's already been persuaded that the no worse off test is satisfied, then the alternative case is not relevant at that stage of the analysis.
Does it become relevant at all?
Well, in some respects, I'm going to come on to this for when we get to ground 7.
Yes.
The alternative case isn't really an alternative case. What we did was said to the judge, even if you were to accept the Knight Frank valuations, including the future estimations of value, then as a result of the protections built in to the note holder's position post-plan, including the fact that all of them are beneficiaries of the security package, and the security package is capable of being enforced where the notes are accelerated following the breach of the loan to value covenant. At that stage, there would be an enforcement, and that other than the 24s who have their prior security, everyone would rank equally. In that situation, actually, everyone would do better than they would do in the relevant alternative. And what we were actually doing was addressing the doomsday scenario in the FTI evidence that was relied upon by the Ad Hoc Group, which was to the effect that the 2029s would get nothing other than the PIK interest that would accrue and fall due to them in 2025.
98 million.
Yes, exactly. And the estimated outcome that Ms. Rickleton suggested was the right outcome in the plan scenario was 10.8 or 10.9%, 10.6%. And that was entirely based on that 98 million. And what we were doing in attacking that doomsday scenario was saying that is simply not a realistic outcome. In fact, what would happen if the Knight Frank valuations were right is that the loan to value covenant would be tripped, there would be acceleration, there would be enforcement, and the 29s wouldn't be in this doomsday scenario of waiting for everyone else to be paid in full and then there being no money for them. That's the way that the argument came in. I think a fair characterisation of the judgment, looking at it as a whole, is that the judge, in the exercise of his discretion, having satisfied himself that the no worse off test was satisfied on our primary basis, felt emboldened to exercise his discretion in favour of sanction, because what he said was, even if I'm wrong in rejecting CBRE and BCG, and I should have gone for Knight Frank and FTI, actually it's not going to be the doomsday scenario that FTI says it's going to be. It's going to produce a better outcome, or it's likely to produce a better outcome than the relevant alternative, and therefore he felt, in my respectful submission, more comfortable in exercising his discretion in favour. And that's the way...
And in fact he goes further and says, even if it does miss, it doesn't miss by very much.
Yes. And what he's doing is balancing the risks, looking at the various options and permutations. Now, that is a difficult exercise for the judge to do. And there are, as my learned friend rightly says, other permutations, because it's not a question of CBRE and NAI Apollo and BCG on the one hand being correct, or Knight Frank and FTI being correct on the other hand. There are a whole raft of possibilities in terms of what each property was worth and what might happen to the value of each property in the future. And what the judge was really doing was looking at this from our perspective defensively, which is, well, if the worst case scenario is the Knight Frank valuations, then in fact the FTI solution, or rather outcome, is simply unrealistic, and actually the outcome would be better than the relevant alternative outcome, or perhaps not missed by much. And in those circumstances, he exercised his discretion in favour of sanction, because what he discounted as the least likely possibility, albeit he was looking at 3 alternatives and there are an infinite number of alternatives, was that doomsday scenario which saw the 2029s only recover their PIK interest.
So, as you say, you'll come back to this on ground 7.
Yes.
But you don't rely on the alternative, so-called alternative case, as needed to get you over the condition A threshold. You say, nor did the judge, you say the judge took it into account as part of the mix when he came to exercising the discretion, having
Yes.
already decided condition A was satisfied on the basis that you've just shown us.
That's right. I mean, there are some infelicities in the way that this is expressed.
It's expressed differently in different places.
But when one gets to the summary, one sees the 3-stage test which has been established as the right approach to satisfying no worse off. So you look at the relevant alternative, you deal with what the outcome would be in the relevant alternative, and then you look at what you get out of the plan and you say, is that at least as much? That's what the judge has done. In the context of stage 3, he's reached his finding on the balance of probabilities in absolutely clear terms. He then includes this slightly odd section, condition A, the statutory test, underneath that 3-part test. And you see what he says there. He may have decided he needed to come back to whether actually he was looking at a menu of options, slightly confusing himself as to stage 3 not being the same as stage 1. But ultimately, there's nothing in those paragraphs that is to the effect of undoing the finding of fact in paragraph 290.
How do you reconcile that with the word ambitious in 291? Ambitious suggests that you may very well not achieve it.
Well, it's not easy to reconcile that, but what one has is his clear finding of fact. What he, I think, is saying there is that it may not happen. You know, it requires things to go to plan in terms of the valuations having been correct and BCG's market model being correct or not far off. Perhaps it's in that regard that he is suggesting that it's ambitious, i.e. it's not certain to happen. But what one can't do with reference to that sentence, or in fact this section 4, is to undermine or to reject what he's already determined in paragraph 290, which is based on paragraph 217 and the other paragraphs I showed you in relation to the findings that he made in relation to the evidence. And it may be here that he, as I said, is seeing what happens if one takes a stage 1 approach at the stage 3 stage. It may be he's already thinking in terms of discretion at this stage and sort of asking himself, well, you know, what happens if in fact that proves not to be the outcome? It's difficult to say with any degree of certainty, but what is certain is the clarity of expression in paragraph 290. And as I say, that doesn't determine the outcome of the discretion question. All it does is opens the door to the exercise of discretion based on the satisfaction of the statutory conditions for cross-class cram-down.
Okay.
So the judge, having satisfied himself on the balance of probabilities that the 2029 note holders would be no worse off under the plan, then turns to that question of discretion. And we know that he was aware, because he made the point clear in paragraph 65 of the judgment, that there's no rule or presumption that the court should sanction the plan simply because the no worse off test is satisfied. That's plainly right, and the judge plainly had that in mind. But it's equally relevant and a factor to be taken into account in the exercise of the discretion that in this case, it's not a question of the 2029 plan creditors merely being no worse off under the plan. On the balance of probabilities, the judge found that they would be paid in full, as would all of the plan creditors. Moreover, as the judge found in paragraph 302(6), that the plan had involved lengthy negotiations and was the product of those lengthy negotiations and commanded a significant measure of support from the plan creditors.
So which paragraph are you looking at?
302 subparagraph 6.
302.
Now, he expresses that as being a weak reason for sanctioning the plan, that is, that it commanded a significant measure of agreement, but it is again a factor which is relevant to the exercise of the discretion.
Well, it's a bit of an odd one, isn't it? Because, I mean, all he actually is saying, he says it's the only restructuring plan which commanded a significant measure of agreement. Yes, but it also resulted in disagreement, dissent.
Yes.
This is why he's been asked to exercise the cram down.
Correct.
I mean, you and I know, particularly, Mr. Bayfield, that when somebody comes and says, this is the only plan or scheme that we can put forward, that isn't always the case. I mean, another plan or scheme often does come along if the first one fails.
If time permits, that may or may not be right, depending on the circumstances.
Yeah, I mean, but merely to say, you know, it's often the case, almost invariably the case, in fact, that when something is put forward, it's put forward on the basis of this is the only plan. It's certainly the only one we're putting forward. And if it's against a time deadline, you know, everybody's told, you know, this is the only horse, this is the only show in town.
Yes, but it tends to be promoted at that stage because it has sufficient support that the company considers it to be deliverable.
Yes, but it doesn't answer in any way the question for the judge, which is this a fair plan?
No, it doesn't answer that question. It is a relevant factor, albeit a weak factor.
I'm struggling to understand why it's, in a sense, it's even a relevant factor. I mean, it's inevitably going to be the case that something that's put forward commands the agreement of some people. But in fact, where you're asked to exercise cram down power, it doesn't command the agreement of others.
Everyone.
And the only question is, in fact, whether the court therefore needs to exercise the power of cram down or not. I mean, it's a sort of sine qua non. You wouldn't be in the position were it not for that. So it's hardly a factor relevant to the exercise of discretion. You wouldn't be there unless the plan commanded a significant measure of agreement. And if he's saying this is the only restructuring plan which is capable of being put forward, if that's what you're trying to say, then no. I'm going to take...
Well, he doesn't say that, and that's not the submission.
Okay, so what's the factor over and above the obvious, which is that you've got some people voting in favour of the plan?
Not just some people. You have put yourself in the position where you've met the jurisdictional tests and you're in the judge's hands on discretion.
Well, he says there's a significant measure of agreement, that's sub 6. But then, as you rightly point out, he says in 7, I consider that to be a weak reason and I don't attribute much weight to it. So, I mean, if you stop there, you might think, well, that really hadn't carried you very much further.
Yes, what does we submit carry us a bit further than that, my lord, is the votes. Because although, of course, one has to start from the premise that one is considering exercising the power of cross-class cram down, one does gain something from looking at the votes. And in this case, 5 of the 6 classes supported the plan, with very high turnouts in each of the classes, and with majorities ranging from 80% to 98% in value. And within the dissenting class, as your lordships know, it was approved by 62.28% in value, with a very high turnout of 95% by value of those entitled to vote at the meeting. And that's recorded in the judgment at paragraph 67. Now, that is again a relevant factor. And we'll come on to this in due course. But when one gets to his paragraph ultimately, in paragraph 302, subparagraph 9, the way in which this paragraph was presented to your lordships was that the judge effectively just decided that there was sufficient support from the votes. Now, that's doing a serious injustice to the judge in this paragraph, and the reason for that is if one reads it more carefully, it says, second sentence, if the plan works, everyone is better off, and the best judges of this are the plan creditors themselves who voted by the requisite majorities in every class for the plan and by 62% in the dissenting class. And the point is that one looks at their 2 things in combination. It's not merely the support of the 5 classes and 62.28% of the dissenting class. It's the fact that on the balance of probabilities, everyone will be paid in full if the plan succeeds. And even if everyone is not paid in full, the likelihood is everyone is better off, including the 2029s. And then looking at the vote and looking at the outcome, albeit the outcome is uncertain, the judge decides that that is a powerful factor in favour of sanction. Now, I need to come on as I will do.
But you, I mean, do help us, because I think, certainly speaking of myself, I do find it quite difficult to try and reconcile what the judge is saying in 7 with what he's saying in 9, unless what one should be taking out of 9 is the first bit of the second sentence, i.e. your submission that everyone's better off. I mean, if that's enough to carry you home, well, so be it, and it doesn't matter in a way what the votes are merely sort of, if you like, confirmation of an appreciation that that is the case. And then that would be reconcilable with what he says earlier. So it's not the fact that you've got a majority, so to speak, across the board. It's the fact that that simply confirms that everyone will be better off under the plan.
Yes, well,
and if that's what he's saying, I sort of understand.
Well, there are 2 possibilities. That's the second of the possibilities. The first of the possibilities, I'm not saying it's wrong. I mean, it's difficult to know precisely what the judge had in mind, but the first possibility is that paragraph 7, which begins with the word nevertheless, is addressed to subparagraph 6. And what he's saying in 7, therefore, is the fact that there were detailed and lengthy negotiations, and it was ultimately the only restructuring plan which commanded a significant measure of agreement, was a weak reason. That's not focusing on the votes at that stage. That's focusing on the genesis of the plan and the fact that it was put forward following detailed negotiations in which a large degree of support was obtained. I think what may be the position is the judge is saying, well, that's a weak reason, but what he ultimately concludes is, given his findings on the no worse off test, and not just the balance of probabilities findings, but then what he goes on to look at as being the various alternatives, bolstered by the fact that a significant simple majority in the dissenting class had voted in favour, that was a powerful combination of factors which outweighed the factors that point in the other direction. And as I
mean, it's quite Delphic, isn't it, in a way?
My lord, what I don't want to say is that he had to produce this under a serious time pressure and all the rest of it, because I open up a different debate. It's not paragraph by paragraph always desperately easy to follow. I accept that.
Yeah, all right.
But ultimately, the judge is conducting that multifactorial assessment. He's taking into account the various factors that weigh in the balance, and he's exercised his discretion in light of that. And as my lord, as Nicholas Patten said, for the court to overturn the judge and set aside the order, the court has to decide that he exercised his discretion as no reasonable judge could have done, or that there was some misdirection that he made, failing to take something into account that he should have done, or taking something into account that he shouldn't have done.
I'll go back to 9. I know there's a danger of trying to dissect this judgment word by word, but the fact that everyone is better off on the findings he's made.
Yes.
And as he correctly says, that's if the plan works. Now, he's found that it's likely to work, but he's already said it's not guaranteed to work.
Yes.
That by itself can't mean, and I think you accept this, that there's a fair wind or a presumption it's not in itself sufficient for the court to sanction the plan. If it was, all you'd need to do was satisfy condition A and condition B.
Correct.
And it is relevant, at any rate, unless you're going to tell us otherwise, and I don't think you are, it is relevant to consider not only whether the likelihood is that everyone will be better off, but also whether it's fair as between the various different interests in the class. So, I mean, suppose, for example, the evidence was, in an insolvency you'll get 63 cents in the euro. On a winding up, most people will get paid in full, but everybody will get at least 70. That would not be enough to say, well, therefore, we should approve it, because everybody would be better off, but it wouldn't be fair.
My lord, one has to take each case on its own fact in my respectful submission. The starting point is that the mere satisfaction of the no worse off test creates no presumption. I accept that. For example, no worse off could mean you're in exactly the same position. If you're in exactly the same position as you'd be in a relevant alternative, but everyone else does fantastically better for absolutely no reason whatsoever, and the outcomes are certain, for example, well, then one can well see why the mere satisfaction of condition A isn't enough to cause the judge to exercise his or her discretion in favour of sanction. One then has, at the other extreme, for example, a position where creditors are treated differently, but it's clear that all of them will be paid in full.
Overwhelmingly likely that everybody will get everything.
Yeah, potentially some will have to wait longer, but they'll get absolutely everything that they're entitled to. And it would be, in my submission, perfectly acceptable in that situation for a judge to say, well, I'm not relying on the fact that no worse off test has been satisfied, but although I can see some unjustified differential treatment, I'm not going to torpedo the plan because of that, in circumstances where I'm sure that all of the creditors are going to get everything they're contractually entitled to, and the alternative to that is something which gives them very considerably less.
And I mean, if I think Mr. Smith conceded in front of the judge that if the judge was, I'm not sure the word was sure, but if the judge was satisfied to a very high level that everybody was going to be paid in full under the plan, then the differential treatment by reference to the relevant alternative might not be enough to dissuade the judge from sanctioning.
And if that's right, that submission or concession, however you want to look at it, is pregnant with this. And it's pregnant with the fact that a failure fully to justify differential treatment is not a bar to cross-class cram down. It will all be fact sensitive, and it will be for the judge to exercise his or her discretion in light of all of the various factors.
A failure to justify differential treatment accompanied by no risk that that differential treatment will have an end result adverse to a creditor, I agree, wouldn't dissuade the judge from sanctioning the plan. But where there is a risk, an appreciable risk, and we can mix as many, I'm trying to avoid
Appreciable
as many
is fair.
adjectives as possible. If there's an appreciable risk that creditors will not be paid in full, which the pari passu principle would address, because the whole point about the pari passu principle is that you share rateably as you go, so that you are treated equally, such that if there is a shortfall, you share it equally. In other words, you bear the burden of the risk equally. If there's an appreciable risk that the thing isn't going to result in full payment, then the focus really does turn onto the reasons for the differential in treatment. Because unless you've got a flipping good reason, why do you expose some creditors to that risk rather than others?
Well, my lord, I understand why you would put it that
so
way.
I'm putting the argument to you.
I
Smith has put, which that's the argument. I'm not saying that's right. That's what we're here to argue. But that's the argument against you, that you can't simply say this was a multifactorial exercise of discretion if the basis upon which the judge has approached it is not in fact being satisfied to a very high level of proof that the creditors will be paid in full under the plan, but nevertheless, as he acknowledged, exposing certain groups of creditors to a risk of differential treatment that they would not face in the relevant alternative.
Lord, I would submit that there is no rule, there's no bright line, that because there is appreciable risk, there has to be a bloody good reason for differential treatment. The position...
Or even a flipping good reason.
Sorry?
Or even a flipping good reason.
Flipping, I apologise if I misquoted you and was even ruder. Lord, the judge...
What experience teaches you probably would have been right in most circumstances, but we're in a court.
Lord, the judge appreciated that there was an appreciable risk. That's clear in his judgment. Yeah. And he appreciated that he was taking into account the appreciable risk. And if one looks back at the final sentence of paragraph 302, subparagraph 9, he says, given the balance of risk, the right exercise of discretion is to give the management of the group the opportunity to implement it. And when he's looking at the balance of risk, he's not only taking into account that he may be wrong that everyone will be paid in full, he's then taking into account other possibilities. He has rejected as being implausible the idea that the 2029s will get completely stuffed. He has taken into account the fact that they will get, along with the other sons, a security package, the benefit of the loan-to-value covenant, the ability as a class to accelerate, and the prospect of enforcement, which would involve probably a BidCo acquiring the properties and avoiding the insolvency discount. So my lord may, if you had been Mr. Justice Leech, have exercised your discretion differently. But there is, in my respectful submission, and we'll come on to look at the cases, no bright line, no
well,
text.
No, of course there's no bright line, but the question is whether the judge approached it from on the correct principle. I fully accept that in order to overturn an exercise of discretion, one has to either say that the judge has reached a result outside the reasonable parameters of judicial decision making, or approached it on the wrong principle, wrong in law or
Yes.
taking account factors. But if you look at 298, where he deals with this point, he says in terms, and I'm looking at halfway down, I might well have been prepared to accept that the plan involved a departure from the pari passu principle if I'd accepted the Ad Hoc Group's evidence and found that the most likely outcome was a significant shortfall, even if the plan was fully implemented. I might have also found this was unfair and a fundamental objection to the plan, but I didn't accept that evidence. But what implicitly that is saying is, if he thought that the most likely outcome was payment in full, only on just a balance of probability, that was sufficient to overcome the pari passu objection.
Well, I don't think he's...
And the argument against you, I think, is that in a sense leaves the Ad Hoc Group exposed, as it were, to up to 49% of uncertainty and risk, that the judge is wrong. And so what the judge has done is failed to appreciate the full significance of the risk.
Well, my lord, in para 298, he's dealing with the most likely outcome. He then in 299 goes to look at what happens if that is wrong.
No, he's actually dealing with discretion and maturity dates, actually. It's under the heading discretion and maturity dates. He's dealing with the argument on pari passu.
At 299?
298.
Yes.
And so the point is...
But one has to read 299 as well.
Yes.
But he does actually find, and this is 301, that the plan involves a greater risk for the 2029 plan creditors than it does for the others.
Yes.
And that is obviously true.
Yes.
And I think what we're getting at is the heart of the appeal is it right that one class should have imposed on them a plan which requires them to accept more risk than other creditors, when in the alternative scenario, everybody's in the same boat. That's the heart of the appeal.
And I totally agree that that's at the heart of the appeal. No question. This appeal is about ground 4. That is at the heart of the appeal. The question is, was the judge required to exercise his discretion against sanction because the 29s bear the risk that he had identified in that paragraph? Or was it open to the judge to decide that in circumstances where there was significant support from the 2029s themselves, including pure members of the class, in circumstances where the 2027s, who are in the same position of the 2029s in many respects, but it's a difference of degree of risk that they're taking. Mr. Smith said earlier, it's a bad plan for the 2027s, but they voted by the
Well, on the FTI figures, they'd get 44%, whereas the 29s would get 10.6%.
But 44 is less than the relevant alternative outcome.
It's a good deal less than 100%, which is what everybody else gets.
And the 2027s voted by the statutory majority in favour. So
yes, but it is quite striking when you look at the figures. They're on 223B, they're all set out together. How the percentage in favour of the plan drops fairly consistently as you move to the right. Now, you can't read too much into these figures because it's all complicated by all the cross-holdings. We don't have the time or the inclination, or as my lord said, it's not really our job to try and interrogate all the various cross-holdings. Well, unsurprisingly, 98.5% of the 2024s were in favour of the plan. Unsurprisingly, the 2025s and 2026s had majorities over 90%, because even on the FTI doomsday scenario, they still get paid in full. But as you move to the right, the 2027 is only just over the 75% at 80%, and the 2029s are under at 62%, quite significantly under.
and I'm going to come back to 2027, but what gets this?
So my question is,
Yes.
was the judge entitled, as he appears to do in 3029, to place any reliance on the fact that the requisite majority in every class of the plan voted for it, because what they're voting for is their own interest. They're not voting as to whether they think the 2029s will be paid in full. They're voting as to whether it's in their interest.
That's right.
So why is it relevant that you've got those majorities in the first four classes who are not affected by the same level of risk?
Well, I would agree that the votes of the 2024s are not a relevant basis. The votes of the 2027s are interesting because you've seen the FTI report and you've heard what Mr. Smith says. They are in a riskier position than the 24s and the 25s, and they voted by the statutory majority in favour. And they could complain about the 24s getting priority security. They could complain about the preservation of the maturity dates. But by the statutory majority, they voted in favour. And there are some points that I'm going to make off the back of that in due course. But therefore, the votes of the 27s are relevant, and the votes of the 29s are certainly relevant.
What I was getting at a little bit before we looked at those. No. It's this. It was really my Lord's sort of point about risk. Pari passu distribution, at its core, as a concept, is one, as its name suggests, of equality.
Yes.
It's designed to ensure creditors bear risk of non-payment equally. So, in a liquidation, you take whatever you realise and you distribute it ratably, so that the risk of ultimately not having enough to pay everybody in full is borne equally. That's the whole concept of pari passu. Sort of does what it says on the tin. In order to depart from that, you need a plan or a scheme.
Or a CVA.
Yeah, okay. I mean, fine. But
it's irrelevant because I just want to mention landlord CVAs in due course.
Yeah, okay. You need a process recognised by the Insolvency Act. If you do BCCI in extremis, you can also have a compromise. But again, for present purposes, plan or scheme, right? To depart from pari passu. But as the judge said in paragraph 74, which everybody acknowledges, in order to depart from it, you need some sort of good reason.
Well,
and the question is, at the moment, as I see it, is whether the judge accurately applied and understood the ramifications of the pari passu principle when he was applying the test which he'd adumbrated in paragraph 74, which everybody accepts was the correct test for him to have set out.
Yes. Can I say two things in response to that? The first point is that my Lord just said you need justification. The exchange that we had a few minutes ago, where you put to me what Mr. Smith had said in the context of certainty, suggests that you don't need justification. Justification and the strength or weakness of it is a relevant factor rather than being some sort of condition.
Well, the justification, okay, you say the justification can be provided by a requisite level of assurance that creditors will be paid in full, such that the pari passu principle doesn't need to operate to protect them.
Well, if that's justification, let's say that it is, then you also have justification if everyone, including the dissenting class, is likely to be better off if the plan is sanctioned.
Well, no, because the problem there is that you accept that just satisfying the no worse off test is not enough.
Correct.
And, I mean, let's stand back a little bit more. Everybody in all these cases doesn't really want to see a formal insolvency because everybody knows that's incredibly value destructive.
Yes.
And everybody will be worse off. So it's what everybody takes as a sort of given that everybody really wants to avoid. Avoiding it will create benefits. Call it restructuring surplus, if you will. That seems to be the buzz phrase that seems to be attached to it, but benefits will do for a moment. The question is, how are those benefits and the risks attaching to the benefits to be allocated? Because you don't get benefits without risks, in other words. And that's the relevance to the exercise of discretion. namely merely satisfying the no worse off test doesn't get you to sanction. You have to also satisfy the court that what's being put forward is a scheme or a plan which is appropriate for the court to exercise its discretion to sanction. And I use that formulation to avoid using the words fair or just or equitable, which are just words searching after a framework or a concept. But you've got to satisfy the court that it's appropriate. And if you're doing something other than would be the position in the relevant alternative, there needs to be some reason for that, don't you? And that's really what the judge is saying.
Well, reasons are given in cases. So, for example, I think my lord in one of the Virgin Atlantic allowed creditors to be left out and paid in the ordinary course, not because they were critical suppliers, not because there was a contagion risk, but because the sums at stake weren't sufficient to make it sort of worth bothering with them.
Well, I think what was probably said, I can't remember. I mean, won't surprise you to know I can't remember what I said last week, never mind in Virgin Active, but there may be cases, and I think if my memory serves me correctly, there were cases where it said the cost of trying to deal with certain very small creditors, in a sense, is disproportionate to actually trying to treat them in a fair way, because you spend more money trying to deal with the tiny creditors in the general scheme of things. So let's just pay them in full. Okay, that's fine. Well, in a sense, that's advanced as a commercial reason why, just like employees, Mr. Smith gave the example yesterday, and we all know that employees very often are left out of compromises because their continued work for the company is required, or trade creditors, going all the way back to Garuda, were left out because everybody knew that the airline needed to keep flying. This is an unusual case because there's no continued business.
Yes.
And the argument is not there were certain creditors being paid in full to everybody's knowledge and everybody just voted in favour knowing that. What's being said here is, amongst the people who were asked to accept an alteration to the position that would have applied in the relevant alternative, some people got more favourable treatment than they would have had in the relevant alternative, and others got less favourable because in a relevant alternative they'd all be in it together.
Yep.
And the judge said that's permissible, but you have to show a justification for it. And the challenge to you at the moment is to show us what the justification is.
Well, there are commercial justifications in this sense, that we in this court will look at what's being done very much through the lens of the relevant alternative. But if one looks at what the plan is in fact doing, it is requiring the note holders to defer some interest, and it's changing some of the covenants that the company owes to them. But the maturity dates stay the same, the principle stays the same.
This is against the relevant alternative, which we were told is an immediate acceleration and equality.
Yeah, my lord, I accept that looked at through the lens of the relevant alternative.
Well, you have to look at it through that because that's the gateway to the exercise of the power by the court that you are asked. I mean, all your commercial arguments might play out well in the negotiations, which doubtless we will come to, that you say were founded on the footing of how the bonds were traded. In commercial negotiations, people outside this courtroom can negotiate as much as they like. But what the plan asks is that the court should exercise a power of cram-down to force the compromise on people who haven't consented.
Yes.
So you have to look at it from the perspective of the relevant alternative because you're in the courtroom. That's the power you're asking the court to exercise, isn't it?
And, my lord, I understand why you would put it like that, and what I'm doing is making a submission that you will consider and accept or reject in due course. But lots of the commercial justifications that have been given for differential treatment are commercial and don't focus on the relevant alternative.
Well,
so, for example, risk of contagion. So all suppliers have to be paid because otherwise there's a risk that people will stop dealing with the company. landlords getting grossly dissimilar treatment on the basis the company says, well, I can't make much money out of this store unless you take half of the rent. Leaving creditors out on the basis it's disproportionate to spend any money on dealing with them. They are all commercial bases for the differential treatment. They don't focus on the legal rights of the creditors in the relevant alternative or otherwise. And looked at commercially, what's going on is that the plan creditors are having their interest deferred and are having some covenants relaxed, but otherwise they're being left as they are to be paid what is owed to them in full on the dates which they contractually are entitled to have payment on. Now, looked at through the relevant alternative, I appreciate that argument doesn't fly. But looked at commercially and looking at what the plan does and looking at the way that creditors have voted on the plan, well, one can take that into account.
Those examples you give are where those concessions and those treatments are necessary to preserve the business, which will pay all the other creditors more than they would get in the relevant alternative. I mean, that's the whole ethos for it. Rather than just simply stop everything and have a liquidation, we want to keep the business going, the company going, the business going. In order to do that, there are certain critical people we need to keep paying, and they can't be expected to work for less than 100p in the pound, or just won't, frankly. Like the aircraft manufacturers in Garuda, they've just got the commercial clout just to say, sorry, we're not dealing with you unless you pay us 100 pence. That's because the continuation of the business is necessary to generate the better returns for the other creditors than they would get if the thing stopped. And it's commercial in that sense.
My lord, I understand.
It has nothing to do with, as I understand what's argued, the argument which is run here, is that the commercial aspects that you mentioned about the way the bonds were previously traded, the way that they were priced, their previous maturities, they have nothing to do with the preservation of the entity and the increase in value that everybody's trying to achieve. They're all just about how you divvy that up. And they, at this moment, I struggle to understand why they are relevant to the exercise of discretion to cram down based upon the relevant alternative.
Yeah, my lord, you've heard the submission. I would add to that as alternative submissions that it is not essential for there to be a justification which is compelling. Alternatively, it is not essential for there to be a justification for differential treatment, period. That will be a factor that goes into the exercise of the court's discretion. And if the court is satisfied that notwithstanding that, it's still appropriate to sanction the plan, well then that's a matter for the court.
Well, you say there doesn't have to be a justification at all. Do you have to tell creditors that? I mean, in other words, because it must follow from your other limb of this that the reason that the court might be, as you put it, emboldened to sanction is that it has the views of creditors, the majority of creditors, behind the plan.
Yes.
If there is no justification from a departure from pari passu, and you haven't told creditors that clearly in the explanatory statement, what justification is there for the court to do it?
Well, it's implicit in the plan and clear from the BCG report, which was appended to the explanatory statement, that in the relevant alternative, all of the notes get paid equally, i.e. they have pari passu treatment, they all get the same result. That's clear on the face of the BCG report. It's also clear from the BCG report that in the relevant alternative, they get payments on their contractual...
Right, you will have to show me this, because Mr. Smith's criticism, amongst other things, is that, he says not only was there no good reason, but he says what's more, you can't rely upon the votes of them, or the court can't have any regard, any significant weight on the affirmative votes of creditors who have not been told in terms this plan does not correspond to the way you would be treated in the relevant alternative to the plan. In other words, it involves a departure from the pari passu principle for no reason.
Well, what one has in paragraph 647 of the X-Plan that my learned friend Mr. Smith showed you earlier.
Just a minute, I filed it. Because, I mean, this is, this is his sort of way of saying that it is counter to your point. You don't need a reason at all. I mean, that's a proposition which I'll have to grapple with. But he says, well, even if you don't need a reason, you at least need to tell creditors that there is no good reason. And if they say, okay, we don't care, we're going to vote in favour of it, well, at least in a sense they've made the decision with their eyes open. But if you don't tell them that this is what's happening to them, then you can place much less reliance upon their affirmative vote. I mean, that's his point. So,
Well, my lord, the explanatory statement certainly does not say there's differential treatment among creditors and there's no good reason for that.
or is there any explanation as to why it's been done?
No. What creditors are told in 647,
Sorry, a page.
it's page 40, it's the first page that Mr. Smith handed.
I've actually put them into the bundle together with the other pages. 40.
It's page 40 at the bottom of the page. That helps.
Yep.
Is that Aiken Gump on behalf of the AHG said that they wanted to vote against and oppose. And it says the AHG also alleges that the restructuring plan results in unequal treatment of pari passu creditors. So that certainly would have put creditors on notice of that argument. They could, of course, have got in touch with Aiken Gump and joined forces with the AHG if they had wanted to. So the point is flagged there in the context of giving them notification of the AHG's position.
That's one sentence referable to somebody else's assertion in, I don't know how long many pages this document was, but it then also goes on to say, in a sense, actually, they're wrong. The group is confident. Substitution is effective. The restructuring plan treats all classes of creditors fairly. Admit it doesn't say and equally. And deals to materially better leads to materially better recoveries. I mean, it's hardly acknowledging that they may have a point.
Lord, I accept that it says what it says.
Okay.
I have to accept that the explanatory statement does not say creditors are treated unequally and there's no good reason for that.
Well,
or anything along those lines.
Or at least say they're not treated in the way they would be treated in the relevant alternative. I mean, I appreciate you're not going to say that because that's. It doesn't say, for example, you are not being treated as you would be treated in the relevant alternative, and the reasons for this are X.
No, and
like normally, to take points I made earlier, you normally say employees of small creditors, trade creditors, are not being treated as they would be in the relevant alternative. They're actually being left out of the plan and paid 100% of their debt. The reason for this is, and that's what's missing.
Well, query whether that is what you would expect to find in an X-Plan in this sort of situation. You're dealing with sophisticated investors in relation to notes which have a minimum denomination of €100,000. It's clear from the BCG report that everyone is anticipated to get 63% in the relevant alternative, i.e. they all get the same result, they rank equally. And it is clear that under the plan, everyone's maturity dates are preserved, save the 24s which are extended.
Yeah, but the preservation of the maturity dates is not the solution to the problem, it is the problem.
Yeah, but, my lord, but the point is all of that will be known to the plan creditors. They can see for themselves that they get equal treatment in the relevant alternative, but in the plan situation, they're not accelerated and neither of their maturity dates are equalised.
Can you help me on that? I mean, the debate that obviously took place in front of the judge about whether or not the plan adequately reproduced some form of pari passu treatment of creditors presumably must have involved the judge accepting, although he doesn't in terms say it, that it wasn't an actual pari passu treatment of creditors, save on the basis of the alternative treatment in the event of a default, an immediate default, because otherwise, I mean, the fact that they had different maturity dates of itself meant that they weren't, under the plan as such, being treated on a strict pari passu basis.
It was.
That's right.
That's right. And Mr. Smith made the submissions to the judge broadly along the lines that he's made the submissions to your lordships.
So whether... I'm sorry, I didn't mean to interrupt.
Not at all. That in the relevant alternative, all of the plan creditors would rank pari passu, and that in the, or under the plan, their maturity dates would be preserved, save the 2024s, with the effect that if the plan company ran out of money before it got to pay the 27s or the 29s, they would be worse off in circumstances where everyone else would have been paid in full. But there's no doubt that the judge was aware of the pari passu principle and the fact that the plan works in the way that the plan works.
Well, if we can just park Ms. Smith's criticism of the alternative scenario because of the problems that it could create at having a default further down the line, leaving only one or more of the groups as creditors at the relevant date. We can just park that for a moment and just deal with the first way the judge dealt with it. So when the judge talks about pari passu in the context of this debate, he's really using as a shorthand, I think, for meaning everybody, if the plan succeeds, will be paid in full.
I think what he's saying, and this is slightly difficult for me because
I'm just trying.
They're not my words, and this is.
I'm trying to help to get your help on sort of 298 following.
My best effort at this is that where he is referring to pari passu in 298 is that he said if the plan's implemented, it's likely the creditors will be paid in full. And I think he considers that if they all get paid in full, then that's not really a departure from the pari passu principle because they all get paid in full. That's what he appears to be saying.
Yes.
And then in 299, what he's saying is actually in the alternative case, which is what he thinks will happen rather than the doomsday scenario.
Well, then you get it automatically.
Then,
it's a liquidation.
other than the 24s, because they have their priority security, the 25s, 27s, and 29s all rank equally because they accelerate and enforce.
But where I think where I'm having a bit of problem at the moment is that if you then go on to 300, we reach the point that you yourself have accepted, that the judge's sort of condition 1 analysis, which to some extent is reproduced in 298, isn't enough in itself. Which is most likely the question? The which is most likely question is not enough to provide you with an answer about how you apportion the balance of risk in relation to the exercise of discretion for the reasons that the judge himself gives in 300, where he says in terms, notwithstanding what he says in 298, that he can't, of course, be certain about these things.
Yes.
So at that point in the analysis, this is all still looking to how he's going to exercise his discretion. He's accepted the fact that he can't be certain that they will be paid in full. And in fact, he goes so far as to say he can't even be certain they're going to be paid on a pari passu basis if there's a default. So he accepts in 301 that there's a greater risk for the 2029 people. And then he goes to give his reasons, which we've already looked at. But if as my Lord puts you, if it's right that at this point in the process we are looking for some sort of justification, if you like, under the plan for a departure from strict pari passu by the preservation of the maturity dates, then you have to ask yourself, do you not, why we're preserving the maturity dates. And I mean, the judge, as you know, has found, and we've seen the evidence, that there isn't in fact any, as far as I can see, good reason. I think it's accepted that it was an essential feature of the plan, although of course it was adopted as part of it. So nobody's putting forward in this case some other reason why you had to preserve the maturity dates, and the judge acknowledges that. So then when he comes to exercise, this is a rather long question, I know, but I'll give you the whole lot and then you can tell me. I'm just trying to explain to you the way I'm reading his judgment mode. So when you get to what is the reason you, judge, are actually exercising your discretion, it actually seems to be no more than the fact that more people have voted for it than not.
I think that was the submission that Mr. Smith put to you, well, and I would submit that is unfair.
That's the case you've got to meet.
Yes, I would say that was unfair on the judge, because the real reason is that he has satisfied himself that all plan creditors are likely to be better off. In fact, on the balance of probabilities, they'll all be paid in full. And that combined with...
But that's the condition one.
Well, no, it's not, because condition one requires only the satisfaction that no one is worse off.
Yeah.
There's a big difference, my lord, in my respectful submission, from being no worse off than being substantially better off.
Well, he accepts that. All he needed to do as a matter of precondition was find that it was likely they'd receive 64% rather than 63%. But he, as you say, he actually goes on to find it likely that they would receive 100%.
And that if not, they're likely to do better than they would in the relevant alternative.
Yeah, but it cannot be, surely, a justification for sanctioning a plan that everybody will be, under the plan, much better off than in the relevant alternative, but nonetheless, the allocation of the restructuring surplus is other than in accordance with the relevant alternative, what would happen in the relevant alternative, for no good reason.
Well, that's not what the judge decided. The judge, in the exercise of his discretion, considered that everyone being likely to be better off and in fact likely to be paid in full outweighed the fact that there was differential treatment and that there was risk that the 29s were incurring that was greater than the 27s, and the 27s that was greater than the 25s, and so on. While
we're on the question of risk, having said I didn't want to have any more of the explanatory statement, I think it would be useful to have at least the index to it, because we've just got a sort of assortment of pages variously numbered. The paragraph that you've identified, paragraph 647, comes in the middle of a section, and I don't know what the section is dealing with. It may just be a general narrative. I don't know. It looks like it might be. What I was interested in is that there does appear somewhat later in the extracts we've been given in the bundle, starting at page 1060 of the bundle and page 100 on the internal pagination. It seems to be something from what is usually called risk factors.
There is a risk factors section.
Yes. Yeah. Normally you would expect a risk factor section to identify a risk. And I'm assuming, because we haven't been told it did, that nowhere was it identified to creditors, certainly a group of creditors to whom this did, this risk, because of failure to follow the pari passu distribution, or to say to the other creditors, don't worry your pretty little heads, you don't bear the risk, somebody else is carrying that one.
Well, can I suggest that we provide...
I put it rather provocatively, but in the risk section, there is no reference to the risk allocation we've been talking about. throughout this hearing.
Yes. Well, look,
I think you're offering to give us the entirety of the explanatory statement, are you?
well, I was going to suggest that, but together with perhaps a note of the relevant bits. Can we do that for tomorrow morning? And would you like it in hard copy or soft copy if the answer is yes?
Well, speaking for myself, I would quite like it in soft copy in its entirety,
Yes.
ideally in a readable and cut and pastable form. So if it's in Word, somebody's got it in Word, that would be ideal. But if not, it'll have to be PDF.
Sure, it can be done in Word.
But it would be useful because presumably it's yay thick. It would be not a bad idea at least to have the complete sections from which paragraph 647 is drawn, and from which the risk factors, the complete risk factor section, so I can at least see the context.
We can certainly do that, my lord.
I mean, you know. Anyway, I'm taking it that in truth, I'm taking that we're not going to find any specific identification of this risk for the 2029 note holders.
Not put in the way that my lord put it.
Or indeed, anyway.
Can we come back to you on that?
Okay. Yeah, I mean, if it is dealt with in some way, then obviously...
There are certainly risk factors identified, including that the properties won't fetch the amounts which it's estimated that they will fetch.
Yes, but does it say, because we have not followed the... because we have adhered to the maturity dates in the notes and not followed the scheme that would apply in the relevant alternative, there is a greater risk to 2029 note holders and a lesser risk to 2024 note holders of non-payment.
My lord, I don't think so, no.
But I suppose you say that we're not dealing here with people buying these things in the supermarket. I mean, these are sophisticated investors who can be expected to understand what's going on.
Yes. I would say that. Whether that's an answer to my Lord Justice Snowden's point or not, I am.
Not saying it is.
We'll have to wait and see. But that's exactly right.
Yeah.
Yeah. I don't think that there's one rule of the contents of an explanatory statement for sophisticated. In other words, as I understand it, you certainly need to work harder to make things clearer to people who are not sophisticated. TNN was one. I think, is it Amigo was the other?
There are lots of retail schemes.
Where you need to work a lot harder to make things clearer to people who...
And try and be more concise too.
But I don't think anybody's ever suggested that if people are sophisticated, you don't actually need to tell them, especially in documents of this length. You do still need to tell people the key points.
Well, I mean, whether you need to tell them something that is self-evident and they will know themselves is another question.
Well, that they'd rank pari passu in insolvency.
Yes.
You said that they would all receive the BCG comparator report.
It was appended to the explanatory statement.
But
Is it your submission that sufficiently identifies where the risks fall under the plan? I mean, specifically, but if you're a 2029 holder, you're less guaranteed to get your money than if you're a 2025 holder.
I don't think it says that in terms, but it's implicit.
Because it says that we'll pay them out according to the maturity dates.
Yes, in the context of an orderly asset disposal programme.
Yes.
So if you've got some assets and you're selling them off and you're not generating new assets, then the assets can go up and they can go down. And obviously, the later you're paid, the more exposed you are to the risk that if they go down, you won't be paid.
I mean, okay, we'll probably better leave this topic because I suspect we've taken you far off your beaten track on it. But some of these risk factors, even looking at one or two of the ones that are there, would seem to state the blindingly obvious, but not the risk you've actually identified. not the risk we've been talking about in this case. Anyway.
Well, my lord, we will provide you with the entirety of the document and try to direct you to what we say the relevant parts of it are. But it's not going to say what my lord suggested that it should in terms of spoon feeding the plan creditors to say in the relevant alternative, your notes will all be accelerated and you will rank alongside one another and rank for payment equally. However, under the plan, your maturity dates will be preserved such that the later dated notes bear a greater degree of risk in terms of the achievement of the values that are anticipated to be achieved through the asset disposal programme. If that's what you're looking for, that's not in the explanatory statement so far as I recall.
Well, the closest you get to it is the table in the comparator report, which shows differential distributions anticipated in the relevant alternative and under the plan, which shows that in the relevant alternative everybody gets 63%.
Yes.
But under the plan it shows the 2024 and 2025 notes being paid out first, while the later notes only just get interest at that stage and you get recoveries later, assuming there are sufficient assets.
Well, can I just check one thing behind me before I answer that? My lord, I think the document that you're referring to is the FTI report.
No, I'm looking at page 33 in the supplemental bundle, which is page 31 of the BCG comparator report, which sets out in blue and black the comparative distributions.
Yes, I mean, what one gets from that is the fact that everyone gets the 63% return in the relevant alternative, but what it forecasts is that everyone gets 100% return in the event of the plan becoming sanctioned.
But more significantly, from your point of view, I'm trying to help you here.
Yes, no, I understand. I just don't want my lord to overstate what it shows.
Is that it shows that in 2025, the 2024 notes are paid out in full, and the 2025 notes. Now you can understand the 2024 notes because they get priority, but the 2025 notes are paid out in full because their maturity comes first.
That is right.
Whereas the later series of notes only get interest. That's where the 98 comes from for the 2029 notes. And then it shows that in 2026, the later notes are all paid out in full. And if you look at the note, it says an early repayment of par could be possible. So the group is expected to have sufficient funds available, but it doesn't. There's no guarantee there.
Yes. All I wanted to make sure is that my lord didn't think that this document modelled the achievement of lower prices
this is what you're putting forward as the plan.
Correct.
And you can see from that, if you are a sophisticated investor,
that is without a doubt correct.
That when you get paid out under the plan depends which series of notes you have.
Yes.
And that's the point you want.
It is the point I want.
But it's not flagged up, you're going to tell us in the explanatory statement.
Well, that is part of the explanatory statement in the sense of being appended to it. And these days, what is the document that is most important to people considering a plan? It's a comparison between the relevant alternative outcome and the plan outcome as modelled by the financial advisors. And the BCG report is what people will, in my respectful submission, go to. So
is your submission that that is enough?
For these plan creditors, that's enough to tell them what the deal is, yes, and that it's implicit that there is greater risk on the 29th. And it's implicit that there is treatment in the plan which does not mirror the treatment under the relevant alternative.
Okay. Thank you. Mr. Bedford, we've been asking you a very large number of questions.
Yes,
and I'm conscious we have to finish tomorrow. I think we probably should let you make the points you want to make rather than the ones we ask you, in the order in which we want to make them.
That's fine, my lord. I mean, one gets to the point quicker this way, and it's probably more helpful to your lordship.
But you
to
do
so.
need to cover everything you want to say.
I would like to, if possible. And I thought my learned friend was going to be an hour of this morning.
Yeah, I know. We asked him questions.
He was a lot more of that.
Yes.
No criticism, obviously, intended of my learned friend. My lord, I just want to show you the authorities on the horizontal comparator, because that's obviously relevant to the exercise of the discretion. And the term seems to have first been coined, albeit it may have been coined in an earlier case, by Mr. Justice Etherton in a case called Prudential Assurance and Powerhouse. It was a CVA challenge case where the CVA creditors who had the benefit of parent guarantees were losing the benefit of those parent guarantees for nothing in circumstances where there was no evidence that those guarantees were worthless. You'll find the judgment in the first authorities bundle at tab 11. So that's page 225. Is my Lord Justice Nugee using the electronic
I've managed to leave my hard copy, first bundle of authorities, at home last night, so I will look at the electronic version.
So tab 11 for the others and page 225 for my Lord.
Thank you.
Can we start, please, by reading paragraph 75 to 77 to ourselves on page 239, please? Now, you'll note that the vertical comparator is referred to in paragraph 77 as a useful starting point and highly material. And in the context of a CVA challenge, that a comparison with a position, if a scheme had been used instead, was a helpful guide. And if one then goes on to paragraph 83, Mr. Justice Etherton, on page 240, says that the vertical comparator went solely to the court's discretion. Said it's clear, however, that comparison with the position on bankruptcy or winding up is not always conclusive as to unfair prejudice.
I mean, just you passed over paragraph 81 on it, is sidelined. I mean, paragraph 81 is Mr. Justice David Richards in T&N basically explaining that as a matter of common law and a scheme, in relation to schemes, you have the no worse off test. We've always had the no worse off test, in truth.
That is true. The difference is the no worse off test as was a test based on it being very difficult to envisage a case in which you fail the vertical comparator and there is still fairness. So it wasn't an absolute test, it was a starting point, and there may be exceptions
I get that, but I mean...
Whereas condition A is an absolute jurisdiction requirement.
I get that, but it's not as if we didn't have a vertical comparator until we got Part 26A plans. It's always been there.
Yes, absolutely.
Yeah.
I'm introducing the vertical comparator and the horizontal comparator as having always existed as...
I'm agreeing with you, I'm just making the point.
Aids to the exercise of the court's discretion rather than hard and fast rules. That's really the point. And the horizontal comparators then dealt with at paragraphs 88 to 90 on page 241. Could I ask you to read those paragraphs to yourself, please? I appreciate this is all very familiar stuff to your lordships, but what I'm trying to get across is that there has never been an absolute requirement to justify differential treatment. The court looks at the vertical and horizontal comparators as useful tests when considering the exercise of its discretion. And one gets that from other cases as well. So just very quickly.
Actually, it was pretty close to that in Garuda, actually. What Lord Justice Peter Gibson said in Garuda, it's pretty close to that. You can leave people out of the scheme, but he didn't say at a whim. He actually did say you have to have some commercial reason. Doing it. He didn't say you could just do it.
Well, my lord, in the authorities, at that point, I don't think anyone was suggesting in Garuda that a good commercial reason was essential or was not essential. The question, in fact, was could you leave these people out at all in circumstances where they otherwise would fall within the class of creditors who would be subject to the scheme?
Garuda was an unusual case because the opposing creditors said, we complain that you have left out of the class of which we form part some other people who are in the same position as us. Yeah. And if you'd have put them into the class would have voted no.
And I think it was put on a jurisdictional basis that you had to include those people in the class.
It was.
And the answer was, well, you don't. The court said if you've got good commercial reasons for leaving them out, you can do.
Yep.
But it wasn't. It was put as a jurisdictional argument and failed as such.
Yeah, it was. I mean, yes, it was put as a jurisdictional argument, but it was a backup. It was a discretionary one in a sense, but it was put as high as jurisdiction.
Yep. Can I just show you as well, if we could go to volume 2 of the authorities, Mr. Justice Zaccaroli's decision in New Look.
You say 2?
I've had the same bundles, I think, as you.
Sorry, I didn't hear.
Oh, sorry.
What tab you said?
Volume 2, I didn't yet. It's tab 27.
Okay.
And if your lordships could turn to page 818, please. Paragraph 107, Justice Zaccaroli said, in considering whether an arrangement is unfairly prejudicial, whilst recognising that it's necessary to have regard to all the circumstances of the case, the courts have developed 2 helpful tests labelled the vertical and horizontal comparators. And I'd underline, obviously, the word helpful tests. And the last case I want to show you on this is Mr. Justice Norris in the Debenhams judgment, in the same volume at tab 18. And it's page 577 is, for my lord, the first page of the judgment, but it's page 580 that the relevant paragraph is on that I wanted to show you. And it's paragraph 12 at the foot of page 580. And there, the judge describes the vertical and the horizontal comparators as useful heuristics for assessing whether a CVA is unfairly prejudicial. And heuristics is right. They're rules of thumb. They're not inflexible conditions. And Mr. Justice Trower picked up on that term, useful heuristics, in Deep Ocean as well. For your note, it's volume 2, tab 23, and the relevant page of the judgment is 716, and the remark is at paragraph 62.
I'm never very sure, Mr. Bayfield, what heuristic means.
Well, I looked it up, my lord, and rule of thumb is one of the ways it is described. It's not an absolute rule, it's something that falls short of that.
It's a shortcut, is it?
Analytical tool, I always read analytical tool for that expression, but whether it's right or not, I don't know. They are analytical tools.
Analytical tools, but not conditions.
Yeah, although Mr. Justice Norris did say, at the end of 12, if you have differential treatment, it must be justified.
He did, and I suggest that puts it too high. Okay. And that actually one is conducting an exercise of discretion that requires consideration of these 2 useful heuristics, but one is not bound to refuse sanction if the second, the horizontal comparator, is not met. Now, the same would have been the case, and is the case in a CVA or scheme in terms of vertical comparator, and that takes one back to TNN and the way that Mr. Justice David Richards put it there. But in fact, when Part 26A of the Companies Act was introduced, the vertical comparator has now been put on a statutory footing as a condition for cross-class cram-down. That is section 901G. I don't need to show it to you, you've already looked at it. And therefore, what happened when Part 26A came in is that what was formerly part of the court's discretion, a helpful test in assisting the court to exercise its discretion, certainly in the context of CVAs and schemes, in the context of a Part 26A plan, became a threshold jurisdictional condition that must be satisfied before one can have cross-class cram-down. And what the legislature did not do was insert a condition elevating the horizontal comparator to a condition for cross-class cram-down, or as a jurisdictional condition to sanction.
You're not saying that by implication, therefore, the horizontal test was made irrelevant?
No, my lord, not at all. The point I'm making is that it has not been made a jurisdictional condition.
No, I understand that.
It therefore remains a useful heuristic, but not something that must be either met or justified before the court can exercise its discretion.
It's not a sine qua non, no.
It'd be quite difficult to draft a suitable statutory condition because you would have to allow for differential treatment where it was appropriate.
Well, my lord, there was, as you'll have seen if you dipped into some of the materials that have been included in the bundle, a suggestion, and you've seen reference, I think, to it in the authorities, that the government was considering the inclusion in Part 26A of the absolute priority rule.
From Chapter 11, but they thought that was too inflexible. They initially proposed that it be subject to a statutory get-out, just and equitable, and then they thought even that was too inflexible. It should be left to a good sense of the judges.
Your Lordship has my submission. Therefore, the horizontal comparator remains part of the overall exercise of testing unfairness. It's relevant to the exercise of discretion, but it's not a jurisdictional condition or the failure to meet it a bar to sanction, as the vertical comparator now is.
It's not a statutory bar. I think there is a question, which is what we're in the middle of debating, as to whether it is a principle which forms part of the relevant framework that horizontal differentials need to be justified.
My Lord, it's a point whereon I'm submitting that is
Putting it
not
too
the
high,
case.
Too high.
Yes.
So, Madam, can I just raise one point? I'm sorry to interrupt my learned friend. It's just my learned friend's submissions seem to be departing from the case we'd understood to be advanced in relation to this part of the law. If I could ask your Lordship to turn up my learned friend's skeleton argument, paragraph 14, page 977. And go to the third sentence of paragraph 14 and the quote. The case in the skeleton argument has been put on the basis, correct basis, that insofar as a plan involves differential treatment of creditors, the correct legal test is the one formulated by the judge, paragraph 74. And then third sentence of the quote. However, even if there are differences in the treatment of individual creditors or class of creditors, the court may still approve or sanction the scheme, provided that there is a good reason or proper basis for departing from the pari passu principle and for differential treatment. So it's been put thus far on the basis that that is the test, and that's common ground.
And my Lord, the proper basis in this case, even if your Lordships reject the arguments, the commercial arguments as to the justification for the departure from the pari passu principle, is that everyone is better off.
Yeah, I think Mr. Smith was objecting to that. I think you did say a little earlier on that there didn't actually need to be a justification.
And that's right, as long as there is a justification in the sense of something that explains why differential treatment between like positioned creditors and the relevant alternative is being doled out.
Yes.
My Lord, on this point, if you do go back to take an extreme case where the expected return in the relevant alternative is very small, say 5%, but the likely or most likely return under the plan is 100%, but the plan involves some differential treatment between creditors who would rank alongside each other in a liquidation, then let's assume further, to make it extreme, that 74% or 74.9% of the class vote in favour because they want their 100%, even though there is some differential treatment which doesn't have a full justification. Is it really the case that the court is bound in that situation to refuse sanction? We would say that would be a conclusion that it would be wrong to arrive at. The position is more nuanced than that. The discretion is broader than that. It would, in that situation, be proper to cram down the dissenting class, where you have 74.9% of them in favour, because although there's been unjustified differential treatment, they're all much more likely to get 100% rather than the 5% that they'll get in the relevant alternative. Now, I appreciate that's an extreme example, but sometimes one needs to test these supposed rules with extreme examples to see whether they're really rules or whether, in fact, they are useful heuristics.
I think I'd put it... Might you put it this way? Parliament has left at large the factors which should inform the court in the exercise of its discretion to sanction under the third stage. Once you've got past the gateway of condition A and condition B, Parliament has clearly left at large the exercise of the court's discretion to sanction or refuse.
Yes.
The court does not sit under a palm tree.
No.
In this jurisdiction any more than, for example, in the unfair prejudice jurisdiction for shareholders that Lord Hoffman identified in O'Neill and Phillips. There has to be some guiding principles for the exercise of a court's discretion. So it's not actually very helpful to a judge just to say, take into account all the circumstances, because it doesn't actually tell you what you're looking for. So it's why, for example, in the unfair prejudice jurisdiction, Lord Hoffman said, well, in that jurisdiction, unfairness starts with what have the parties agreed, contractual framework, and then you, in certain circumstances, can have regard to established equitable principles based upon personal relationships. So he explained a framework to give some meaning to the concept of fairness. Now, we don't even have the concept of fairness here. We just have a discretion at large.
Yes.
But there has to be some sort of framework for the judge to start from. It's a starting point. And the obvious framework that you have is the relevant alternative, because the whole point is the plan is being put up as an alternative to the relevant alternative. And that indeed is the first gateway condition. Now, if in the relevant alternative there is a particular treatment of creditors, why should that not be at least the starting point for the analysis of the horizontal comparator, as between, in other words, the fairness as between creditors? Why is that not at least?
Well, it is. I'd accept that it's the starting point.
Right.
It's not determinative.
No, I didn't say it was. I was saying, it's a word. It would be legitimate, wouldn't it, for the court to start from the proposition that pari passu, if pari passu exists in the relevant alternative, it should be the starting point for the examination of the fairness of the plan or the reason why you sanction it or withhold sanction. And then that leads naturally to the question, well, if it's not the same, what's the reason for the difference?
Yes, I accept that.
Right. I mean, I'm
But-
not saying it's determinative.
No.
I haven't said it's the end point. I'm just saying it's a starting point.
And I'd accept that it's a starting point. I mean, the court is going to expect that, but that may not accord with the commercial expectations of the parties, may not. And equally, if in fact there are more powerful reasons for exercising the discretion in favour, notwithstanding the fact that there is a departure from what the court would expect, then the court is still entitled to exercise its discretion in favour of sanction.
You can't investigate the commercial expectations of the parties, as for a reason Sir Nicholas Patten said yesterday. I mean, the court can't get involved in trying to interrogate what parties might have thought or expected in any individual case. Surely.
The court may.
I mean, the expectations of the parties are conditioned by what the alternative to the plan is, because that's the position they find themselves in the same way you formulate classes by reference to rights in the relevant alternative, in fact, as per Hawke. You know, the whole structure of plans and schemes is formulated around asking division of classes, you know, what are your rights and interests in the relevant alternative?
I'm not disagreeing with my lord.
Right, okay. So, for example, how the parties may have conducted their negotiations leading up to the plan would seem to be of far less, if any, relevance at all, because it's just impractical for the court to get involved in that. What the court can do, though, is to say, is there a departure from the principles that would apply in the relevant alternative, and if so, has it been explained, or at least has it been at least explained to the people who voted on the plan, such that we can assume that they must have taken it into account? I mean, isn't that the structure of plans and schemes?
Well, but what one can also do is look at the likely outcome for the relevant class from the plan, and look at the way that they have expressed themselves at their class meeting, and say to oneself, well, either judge may come at this from the perspective that I would expect this differential treatment to be fully justified, but I can see that the creditors themselves, not all of them, but a simple majority of them, including some with no cross-holdings, consider that, notwithstanding the departure from the pari passu principle, which they are capable of inferring from the BCG report is going on, are content with the balance of risk that they are taking, because they're happier to have that chance of getting paid in full.
But the danger of that approach is that you put into the hands of the majority, who will benefit from the particular solution that's adopted, the ability to ask the court to cram down the minority who won't.
Well, my lord, that's an interesting point. Let's assume in this case there had been no 2029s. We know that the plan from Mr. Smith's perspective is bad for the 2027s. We also know from the FTI report that they may suffer a shortfall on the Knight-Frank doomsday scenario. If there had been no 2029s, you would have had a dissenting 2027 note holder crammed down by the vote of other 2027 note holders. If my lord is right to put it in that way. maybe I haven't explained myself too well. The 2027s and the 2029s are in materially the same position in that the 24s get priority and their maturity dates are preserved, and the risk of not recovering in full is heightened for them as compared with the other classes. It's just that it's worse for the 29s than the 27s.
Yeah, but the headroom for the 2027s is considerably greater, isn't it?
It is, but on the Knight Frank valuations, as my Lord Justice Nugee said, they take a significant hit. So let's assume there had been no 2029s. The 2027s, as we know, voted in favour of the plan. Now, one could say there's differential treatment of the plan creditors, including the 2027s. There's no compelling reason justifying that differential treatment.
Yeah,
and therefore, the court should exercise its discretion against sanction. Now, the answer to that might be, well, reasonable, rational members of the 2027 class have voted in favour, the statutory majority has been achieved, therefore I'm going to cram down the dissenting members of the 2027 class.
well, within a class, I don't have any problem at all, provided that you eliminate cross holdings and the risk of collateral advantage and all that sort of thing from the votes within a class.
Yes, one looks at the pure members of the class and sees.
I don't have a problem saying that if you can respect within a class, you apply the rationality test that we're familiar with from schemes, provided you've managed to eliminate the factors that might cast doubt upon the vote within a class. I don't have a problem. But this is not within a class. This is class against class.
But what my lord is then doing is saying, in the context of a scheme where you're cramming down a dissenting member of the class, the horizontal comparator test sort of falls away and is dissolved by the majority vote, so long as the vote is representative of the class. But in the context of cross-class cram down, it becomes a bright line that prevents the court from exercising its discretion.
You're the one who's introduced the bright line wording into this. It's not me. I don't think I've ever said it's a bright line. What I'm saying is there is a material difference in approach between the situation that the court is faced when it's sanctioning a scheme, where ex hypothesi the majority of every class has voted in favour and the classes have been constituted of people whose interests are common, such that they can consult together with a view to their common interest. And therefore that people who have the same interest who can consult have voted by the relevant statute majority in favour. The 75% gives you perhaps a greater assurance that they're being rational than just a bare majority. And you just, all other things being equal, go with the majority. That's what we do. In schemes.
Or restructuring plan where there's no dissenting class.
Or restructuring plan where there's no dissenting class, where you're not asked to exercise the cram down power, see Virgin Atlantic.
Yeah.
But where you are asked to exercise the cram down power, by definition, you have two groups of creditors, two classes of creditors, who were not put into the same class because their interests were sufficiently dissimilar that they could not consult with a view to their common interest. Otherwise, you would have put them into the same class. So you start from the proposition that they have different interests that cannot consult together, and one of them is in favour by the requisite majority, and the other one is either opposed or not in favour by the requisite majority, and so that the question then is a very different one from the usual sanction of a scheme.
I understand the difference in terms of the position that one is in, but one may have, in this example, 2027s who are being crammed down by other 2027s, where the horizontal comparator test is exactly the same test as for the 2029s in the context of cram down. In this sense, that if you are saying for the 2029s that there has to be justification for the differential treatment, and my Lord may or may not be going that far, but if you're saying you have to have different justification, otherwise the court cannot or should not exercise its discretion in favour of sanction, I do query how that can be quite so different from the position of a dissenting 2027 note holder who will rely on precisely the same absence of justification for the horizontal comparator, and yet be crammed down because other people in the class have taken the view that notwithstanding the differential treatment, the lack of justification, they're better off if the plan or scheme is sanctioned. It does elevate in some way the horizontal comparator test from the way that my Lord sees it as existing in the context of a scheme. One appreciates in the context of a scheme that class composition means that each class should have materially similar rights. That doesn't mean that differential treatment has to be or is justified. It's just how class composition works. The class is entitled to take the view that notwithstanding the differential treatment, they think that the plan is a better scheme, is better than the relevant alternative. In the context of this plan, the judge had the 2027s voting in favour, notwithstanding the non-compellingly justified differential treatment. The judge had the same in relation to the 2029s, where the risk is greater. I accept that. The differential treatment is the same. Why is it that for the 2027s, just because the majority's been achieved relatively narrowly, the court doesn't worry about the lack of justification of the horizontal comparator and says, well, everyone thinks they're better off, so be it. But because one's in the 62.2% bracket for the 2029s, not the 75.1% bracket, suddenly one has this roadblock to the court exercising its discretion. The votes of the 2029s are irrelevant. The outcome being a better outcome is not a sufficient justification or basis upon which to have differential treatment, and the plan gets torpedoed.
No, I mean, I see the argument if, there are other factors that come into the argument, such as whether there's been proper disclosure of the difference, etc., and also the question of cross-holdings within the 27 class.
Yes.
But I see your point is, if I'm a dissenting creditor in the 2027 class, I have to go with the majority of my colleagues, rather than complain that the pari passu distribution, as regards other classes, is not being respected, because the majority of my cohort have thought it commercially in their interest. Yeah.
Well, that may be a convenient moment.
How are you doing, Mr. Bearfield?
Very, very poorly, my lord.
Yes. That's not your fault.
And I was referring to timing, I should say. I hope. I am not very far through my speaking notes.
No. Although you have covered quite a lot of ground.
I've covered probably quite a lot of grounds 3 and 4. I'll need to go back to Chambers and work out what I can strip out. What we have been dealing with is, as I submit, the heart of the appeal, the issue that really matters. How the judge has expressed himself in relation to whether there's a better plan and all of the rest of it, I will go through, but it does strike me that those points don't take my learned friend very far, and he's maybe being slightly unfair to the judge in relation to what the judge has said. The critical issue is ground 4, and we have made a lot of progress, at least in debating it.
Do you want us to consider starting early? Are you in sufficient difficulties that you're getting concerned you won't have a fair opportunity to say what you want to say? Or?
A number of the grounds can be taken really quite quickly, I hope and think. The one ground that probably will require me to spend a little bit more time on it than those other grounds is ground 7, just so I can...
This is the alternative. ...
ensure that the court fully understands how that developed and what the arguments were and what the judge concluded. I have given you a prelude to that already. Mr. Smith, I suspect, will ask him a reply of half an hour or so.
20 minutes, I suspect, would be fine.
So, I mean, I suspect I will be finished by 4 o'clock tomorrow evening to start at 10:30 because the critical submissions have been made and repeating them will not change your view of them one way or the other. I mean, I'm obviously happy to start early if it doesn't inconvenience anyone, including the court staff. It would be helpful, but I can't at the moment say it's essential because A, it's very difficult to know what I still need to cover without going through my note, and B, it's impossible really for counsel to predict what questions will be asked and at what length.
I think we'll stick with 10:30, Mr. Bayfield. If we're asking you too many questions in the morning, we'll take a vow of silence in the afternoon so you can just get on and say what you want to say. So we'll say 10:30.